Jason.
For the Cody Davidson case. And that now just leaves me with, nor the Felton Knight. So our next case this afternoon, our last one is People of the State of Michigan versus Charles Sarrazin. Hopefully I said that correctly. Sarrazin, sorry, I got it wrong. I apologize. This case number is 26-3664-FH. Appearances from counsel, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, the Assistant Prosecutor from the South County.
Robert Hertzell, Mr. Sarrazin, and joint until.
All right, thank you. Mr. Sarrazin again is at in pretrial custody at the table of counsel. I'm told today that the parties are going to enter, that the parties have reached a pretrial agreement and that the defendant's going to enter a guilty plea. The defendant, who is currently charged with operating while intoxicated as a third offense, as well as having a fourth habitual offender enhancement, have agreed that the defendant will plead guilty to that single count of operating while intoxicated third degree as a second habitual felony offender, and therefore the fourth habitual felony offender enhancement will be dismissed. Did I get that correct, Mr. Ringstrom?
That is correct, Your Honor.
Mr. Hartel?
Yes, sir.
All right, Mr. Sarrazin, is that how you wish to handle it? Yes? Is that how you wish to handle it? Do you wish to enter that plea that I just covered?
Yes, sir.
All right, please raise your right hand to the best that you can. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
I do, sir.
You may lower your hand. All right, so looking back on February 8th of this month and this year, were you on probation, parole, or bond anywhere at that time?
No.
Okay. You are currently charged on a piece of paper called a felony information with a single count. That single count is operating while intoxicated as a third offense. Now that is initially a felony punishable by a minimum of $500 to a maximum of $5,000 in fines plus costs. And then either a choice of a minimum of 1 year to a maximum of 5 years in prison. Or in lieu of prison, the court could give you probation, and there would be a minimum of 30 days up to a maximum of 1 year in the county jail. 48 hours of that jail would have to be served at least in consecutive order. There could be a minimum of 60 to a maximum of 180 days of community service, rehabilitative programming, cost for those programs, cost for the prosecution of you, and cost for any government emergency responses. Plus, there would be mandatory vehicle immobilization of not less than 1 year or not more than 3 years. Additionally, the Secretary of State will take sanctions against your license and revoke your license permanently or put you on some period of suspension or limitation. Do you understand?
Yes, sir.
Now, there's also something called a fourth habitual felony offender enhancement. What that means is if you were convicted as a fourth habitual felony offender, within the discretion of the court, that maximum punishment of up to 5 years could go up to life. However, instead of that, I'm told that you're going to admit to being a second habitual felony offender. Now, that means that the maximum punishments go up from up to 5 years up to a maximum of 7.5 years. Do you understand that?
Yes, sir.
Again, there would be fines, costs, licensing sanctions, and so forth. Do you understand?
Yeah.
Now, I have here this pre-trial agreement. Looks like the parties and you have signed it. Did you sign this piece of paper, sir?
Well, I believe that one he may have had me sign with.
Oh, I just say with permission. All right, thank you. Mr. Hartel, is that what happened?
Yes, he did sign his advice of rights himself, but I signed that one for him.
All right, thank you. Now. Sir, if you enter a plea of guilty and I accept that plea, you will not have a trial of any kind. Does that make sense?
Yes, sir.
I'm holding up this other piece of paper that Mr. Hartel gave to me, and he just mentioned it. And at the top, it says advice of rights. At the bottom, it appears to have your signature. Is that your signature?
Yes, sir.
Now, before signing, did you read through all these rights that are listed?
Yeah.
Did you understand what you read?
Yes, I did.
And even more importantly, do you understand that if you enter a plea of guilty and I accept that plea, you will be forever waiving these rights as they apply to this particular case?
Yes.
Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now. Other than the terms of the agreement, have there been any other promises, threats, coercion? All right. Now, I can tell here on this form that Mr. Hartel has talked to you about the Michigan sentencing guidelines, and he's given an estimate that he thinks that those guidelines score a minimum sentence somewhere between 10 and or 28 months.
Oh, I was just telling him that was actually the prosecutor. who
Oh,
was
okay, all right.
discussing.
But anyway, sir, on this form that you told Mr. Hartel he could sign, it gives an estimate as to what the sentencing guideline range would be. And they estimated it would be between 10 months and 28 months for the minimum end of your sentence. Do you understand?
Yes, sir.
Now, that is just an estimate. It's not a promise. The guidelines are not mandatory upon the court. You understand?
Yes, sir.
So has anyone made any promise to you or led you to believe to exactly what the sentence would be that I would give?
No.
All right. Knowing, have you gone over everything with Mr. Hartel about the case? Yeah. And has he been able to answer all your questions to your satisfaction? And you believe that, are you satisfied with his advice thus far?
Yes, sir.
And do you believe entering this plea today is in your best interest? Maybe not what you want to do, but.
Yeah.
All right, thank you. As to count one, operating a vehicle while intoxicated is a third offense. How do you plead, sir? All right, before the court can accept that plea, I'm going to ask you some questions. Looking back on February 8th of this year, just a couple weeks ago, out in Forest Township here in Missaukee County, were you operating a vehicle at that time?
Yes, sir.
And what time of day or night was it? Do you remember?
4 or 5 o'clock.
In the afternoon?
Yeah.
And were you stopped by a police officer?
I went in the ditch.
Oh, okay. And looks like that was out on Holton Lake Road or otherwise M55.
Yeah.
And did an officer come up upon you?
Yeah.
And prior to putting that car in the ditch, had you been consuming alcohol?
Yes, sir.
And what was it that you had to drink, sir?
Beer.
Okay.
Whiskey.
And Mr. Brinkstrom, do we have a intoxilizer or blood draw?
It's 0.155, 0.157.
Mr. Hartel, does the defense stipulate to accepting that result for the taking of the plea and sentencing?
We do, Your Honor.
All right. Were you the one who was driving the car before it went into the ditch?
Yeah.
And you had been driving it after or while consuming alcohol? Or
Couple miles, yeah.
okay, all right, thank you. And also, sir, is it true that you were previously convicted in this court on or about June 2nd of 2014 for operating while intoxicated third?
Yeah.
Mr. Rickstrom, do you believe the defendants provided the factual basis to support the taking of the plea?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements we haven't talked about?
I am that.
And do you believe the court's in compliance with Mr. Rule 6.302?
I do.
Mr. Hartel, do you agree with all three positions?
I do, Your Honor.
Thank you, or statements. All right, one moment. This court hereby finds that the defendant's plea has been made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements as well. I'm sorry, for the count one. Oh, wait. It did not. I see what I missed. Nobody else is tracking it. Good thing I caught it. Maybe I'll just say on the record that I was testing you. Sir, with that, what I asked earlier satisfied the habitual offender's second element. It did not address the drinking and driving third. Sir, is it also true that you were convicted of operating while impaired on November 25th in 1985 in Lenawee County?
Yes, sir.
And is it also true that in that same county on September 28th of 1987, you were convicted of that same offense?
Yes, sir.
Now that the court finds that the defendant is guilty of operating while intoxicated, a third offense, as well as being a second habitual felony offender, and that the habitual enhancement is not the one for which he has the third, that supports the plea for the third. Sir, we'll be back here in about 4, maybe 5 weeks for sentencing. Between now and then, an agent of the Michigan Department of Corrections, also known as a probation or parole office, such as Miss Odell over there, has to prepare a pre-sentence investigation report. One of these reports must be prepared when anyone is convicted of a felony in a state of Michigan court. There are 3 steps that involve you in the preparation of this report. First, you're going to complete a packet. That packet has just been provided by the deputy clerk to the detective behind you. You're going to complete it out, fill in as much information as you can, and turn it back in. You will then be subject to an interview from an agent with that office. You have the right to have your attorney present during that interview. And third, Mr. Hartel will come by and visit with you after he gets that report. And that's generally about 2 weeks prior to coming back for sentencing. Each side has the right to come back to this court and request corrections, make objections to the content, the scoring of the guidelines, and other things. Now, this report will tell the court about the pretrial agreement, what happened, information about prior criminal convictions, how you score on the sentencing guidelines, which again are not mandatory, how you have performed on bond, parole, or probation in the past. It will also make a recommendation as to the sentence. Please keep in mind that whatever it recommends is strictly that, just a recommendation, as it is the court alone who makes or issues the sentence. Do you understand what I've just said? All right, do you have any questions, sir, about what we have done today?
No, sir.
The court's does revoke bond. It remands the defendant into custody here at the Missaukee County Jail. Anything further, Mr. Hartel?
It might be a moot point with the court remanding due to there being a finding, Your Honor, but if the court was willing to entertain the idea of a bond motion pending sentencing, we would ask for the opportunity to do so.
You can always file it. I'm not going to tell you no, because I have no idea what you would put into it. The likelihood, though, of me modifying the bond based upon seeing at least 5 or 6 drinking and drivings, I'm not likely to. But that's all right. I don't know. You might find some great information that I don't know about. So please make sure you do your job, feel what you need to present to me, you do. I would never discourage anyone from filing an motion with this court.
Thank you.
All right. Thank you all very much. Anything further, Mr. Rickstrom?
No, Your Honor.
Ladies and gentlemen, thank you for your time. We are hereby adjourned. All right. I think we're done, right, Nancy? Linda?